A federal appeals court has ruled against the Second Amendment. Now, what does that mean? They didn't actually rule against the Second Amendment. They ruled that assault weapons are not protected by the Second Amendment, and this is not the first ruling that says so. Now, a federal appeals court on Tuesday upheld Maryland's ban on assault weapons and high-capacity magazines, ruling that Second Amendment protections do not extend to what it called weapons of war. In fact, the court ruled 10-4. So the majority of the judges, obviously, the vast majority of judges in this case, ruled in favor of the law in Maryland. Now, Judge Robert King of the Fourth Circuit Court of Appeals in Richmond, Virginia, said that the decision rendered in 2008 explicitly allows governments to regulate firearms similar in design and function to those issued to members of the military. He writes, the decision marks the 5th time that a federal appeals court has upheld a state assault weapons ban, but it goes, oh, I'm sorry, he didn't say this. This is from the analysis of the ruling. The decision marks the 5th time that a federal appeals court has upheld a state assault weapons ban or law, but it goes further than those previous decisions. It is the first to exclude AR-15s and other similar guns from Second Amendment protection on the grounds that they are virtually indistinguishable from weapons of war. And Maryland's assault weapons law is similar to California's, requiring registration of those weapons lawfully possessed before the passage of the ban. So in Maryland, if you had these weapons prior to the passage of the law, you're allowed to keep them. It just means that you can't buy more assault weapons and you can't transfer them privately to other individuals. And the same goes for high-capacity magazines.
So even in the Heller versus District of Columbia, the 2008 Supreme Court decision that said that handguns are covered by the Second Amendment, that's the essence of the decision, they explicitly allowed the government to regulate firearms that were similar to ones that are issued by members of the military. So this is exactly what Maryland did. It was exactly as the conservative ruling of the Supreme Court envisioned. So the Second Amendment does not give you an unlimited right to arms. I think that it only gives you a right to arms if you're part of a well-regulated militia, but the Supreme Court disagrees with me. I understand that. But even the conservative opinion of the Supreme Court says, of course, there's a limit to it. Yeah. You can't roll into town with a tank or an RPG because of the Second Amendment. So, so Maryland was perfectly within its constitutional boundaries to say, yes, you can't have a tank, an RPG, or an AR-15, exactly as the conservative court ruled in 2008.
Exactly, yeah.
So, and then if you're a conservative, there's one other thing that you should care about. You know how conservatives always talk about activist judges that overturn the will of the people? Well, if you said that Maryland could not pass this law, you would be an activist judge overturning the will of the people. Right. The people of Maryland voted for this. They don't want these type of military-style weapons. And you might think, oh, no, it's not a military weapon. That's like your opinion, man. Right. But they voted in Maryland, and their opinion is that it is a military-style weapon, and they don't want it in their state, and it is perfectly within constitutional boundaries.
So, in fact, if you're conservative and you're concerned about this, you should know that one of the judges who voted in favor of this ruling was a conservative judge. This is a quote that I actually wanted to read earlier. So, Judge James Harvey Wilkinson III, a conservative appointed by President Ronald Reagan, wrote in a separate concurring opinion that assault weapon laws are a wholly separate subject from constitutionally protected handgun ownership for self-defense. He wrote that judicial decisions to reject assault weapons bans would be disenfranchising. So,
meaning that taking the right to vote away and anti-democratic. So if you're not an activist judge and you're a true conservative, you would let the voters' feelings on that stand. And by the way, that means another state could allow it. You know, so if you live in Montana and you guys want to shoot up the deer to your heart's content, or whatever else you want to shoot up, that same judge would say, that's like your opinion, man, and that's called democracy. But Maryland doesn't want it, and they get to have the law that they passed. Let's put some watchers on the wall, investigative journalists to run down the Trump administration and the establishment. You can make that happen. TYTnetwork.com/go.